Hello everybody, I am Rajrishi Ramaswamy. Today we shall be seeing two aspects of the IBC which were brought in through an amendment in 2021. Firstly, the pre-packaged insolvency resolution process which is envisaged under chapter 3A of the code, and secondly, the fast-track insolvency resolution process. Now, before going into each of these processes, it is important to understand why these processes, particularly the PPIRP, was brought into place. Now, if you recall, 2021 was the period during which India was suffering multiple economic ramifications as a result of the COVID-19 pandemic. Now, the government of India at that time, in order to recuperate and ensure the sustainability of a few industries, brought in a lot of reforms. Now, many of these reforms were particularly directed towards the MSME industries, right? And this amendment to the IBC is also one such step in that direction. Now, before proceeding to analyze what the provisions are which deal with PPIRP, it is important for us to understand the process as a whole, because that is exactly what the IBC is. Once you understand the process, once you understand the overall outlay and how things work in the IBC, it is easier to understand the provisions which are just filling in for the overall procedural aspects. Now, once you have understood the CIRP procedure, the PPIRP procedure is much simpler to understand, because essentially the PPIRP is divided into three legs. One is the informal stage, second is the application stage, and the third one is the formal stage, which is very resemblant to the CIRP procedure. Now, the reason behind why the PPIRP has these three aspects as compared to the CIRP, which is quite linear, is because PPIRP is applicable exclusively to MSMEs, which are registered under the MSME Act of 2006. Now, these companies have an entrepreneurial aspect to them, which are generally not required in most corporate debtors or most companies which are undergoing CIRP processes. Therefore, what it becomes necessary for MSMEs to have a chance and to have a say in their own restructuring, right? Because of this entrepreneurial aspect, the board of an MSME is given the opportunity to have the say in how its own resolution should take place. Now, this is why the PPIRP has the informal process, something which we cannot see in the regular CIRP. Now, coming to the process as a whole. In a CIRP, the first step essentially is the adjudicating authority being approached by a financial creditor or an operational creditor or the corporate applicant. In case of a PPIRP, please note that it will be only the corporate applicant. If at all an application is being filed, it can be done only by the corporate applicant and not through any of its creditors. The corporate applicant here, of course, is the corporate debtor, which is the MSME. Now, before proceeding with the process as a whole, we need to understand two other terms which are quite important here. One is the BRP and one is the BAP. Now, the BRP stands for the base resolution plan. In very simple terms, the base resolution plan is not very different from the resolution plan which is submitted in the CIRP. Only difference being the base resolution plan is prepared by the corporate debtor itself, right? This is the corporate debtor's own model of how it will revive its own company and ensure that its business is continuing as a going concern, right? Now, this base resolution plan will be up for the consideration of the creditors, who will deliberate and discuss upon it, and only if they find that the base resolution plan is not sufficient, then prospective resolution applicants are invited by the resolution professional, similar to an CIRP procedure. Now, when these prospective resolution applicants are invited, the plans that they submit, right, out of these, one plan will be selected, which is the BAP, which is the best alternate plan. This is the plan which will finally be approved by the committee of creditors and will then go to the adjudicating authority, which is similar to the process under the CIRP. Now, earlier I told you that PPIRP is divided into three stages, right? One is the informal, one is the application stage, and one is the formal stage. Now, the informal stage is basically very internal in nature, where the corporate debtors, promoters, and board of directors, partners, whoever the leading authorities of the corporate debtor are, will take the decision that the corporate debtor needs to go under PPIRP. Then a list of creditors is compiled, the base resolution plan is drafted, and all of these are sent to creditors for them to collectively come together and initiate a discussion, right? Basis the discussion, and this also will include documents such as preliminary information memorandum and the RP report, which we shall be seeing when we go through the procedure in detail. Basis all of this pre-discussion, an application will be filed, which will commence the PPIRP proceedings, and then basis the BRP being admitted or being approved or rejected by the COC, then subsequently the BAPs will be called for and the process will continue. Now let's get into the procedure, the provisions to understand this procedure in a more intricate manner. Now chapter 3A starts with section 54A, which carves out who are the corporate debtors who are eligible for PPIRP. Now here we can see very clearly that application for initiating PPIRP can be made in respect of a CD classified as an MSME under subsection 1 of section 7 of the 2006 Act. Therefore, here itself section 54A very clearly says this entire chapter is applicable only to MSMEs, and the reason for the same we have just seen. Now subsection 2 says, without prejudice to 1, an application for initiating PPIRP may be made in respect of a corporate debtor who commits a default referred to in section 4. Now as you may recall, section 4 presently says 1 crore is the threshold for the default. So here also the default needs to be 1 crore. However, under subsection 2 there are a few more conditions on the eligibility of an MSME to apply for PPIRP. Firstly, it has not undergone PPIRP or completed CIRP during the last 3 years of to the initiation of PPIRP, right? So previously it should not have undergone CIRP within the last 3 years, or it should not have undergone PPIRP within the last 3 years. Secondly, is not presently undergoing CIRP. Thirdly, no order requiring it to be liquidated is passed under section 33. Fourthly, it is eligible to submit a resolution plan under section 29A. And lastly, financial creditors not being related parties representing in such manner have proposed the name of the IRP for conducting the PPIRP, and the financial creditors not being related parties representing not less than 66% in value have approved such proposal in such form as may be specified. Now here you may notice that clauses D and E, the specifications thereunder are carved out in a manner suitable only to PPIRP, right? Now why is clause D here? This is because the eligibility to submit a resolution plan is quite important to determine whether or not an entity will have the capacity to ensure that the corporate debtor continues as a going concern, right? In the case of a PPIRP, it will be the MSME or the corporate debtor itself who will be submitting the resolution plan at the first instance. Therefore, here also it is crucial and of the utmost necessity that the corporate debtor meets all the essentials under section 29A. So that is the logic behind clause D. Now coming to clause E, which deals with unrelated financial creditors, right? It says the resolution professional's name has to be proposed by the financial creditors who are unrelated, and these financial creditors representing not less than 66% in value of the financial debt have to approve such proposal. The logic behind this again is, as opposed to the IRP's appointment which we have seen in CIRP proceedings, here the IRP's appointment is done at one stage subsequently, right? So therefore, even for this you require 66% approval. Now the proviso to clause E clarifies that where a corporate debtor does not have any FCs who are unrelated, the proposal and approval under this clause shall be provided by such persons as may be specified. Now here it is generally the operational creditors, because those are the only other class of creditors that are relevant under the IBC. Now coming to clause F, which is the next condition. The majority of the directors or partners of the CD, as the case may be, have made a declaration in such form as may be specified, stating inter alia that 1. The CD shall file an application for initiating PPIRP within a definite time period not exceeding 90 days. 2. PPIRP is not being initiated to defraud any person. And 3. Name of the insolvency professional proposed and approved to be appointed as resolution professional under clause E. Therefore, here we can see, like I said, there is an informal stage that precedes the initiation of the PPIRP. In this informal stage, these are the aspects which the corporate debtor will have to look into, which is firstly make an assurance that immediately after the PPIRP process has been started, we immediately 90 days within the date of us making this application, we shall begin with the PPIRP. Second, the PPIRP is not to defraud anybody. And lastly, who is the insolvency professional who has been approved by 66% of the unrelated financial creditors. Now clause G says, members of the corporate debtor have passed a special resolution, or at least 3/4 of the total number of partners, as the case may be, of the CD have passed the resolution approving filing of an application for initiating PPIRP. So till here is your informal stage or internal stage which precedes the application for the PPIRP. Therefore here the corporate debtor will have to make certain assurances before initiating it, and including the aspect that the application will be filed within 90 days of the period specified thereunder, take approvals from the creditors for the name of the insolvency professional, and lastly take a pass a special resolution or a 3/4 approval from the partners for approval of the filing of application for PPIRP. So this is your initial stage. Now subsection 3 says, the corporate debtor shall obtain an approval from its FCs not being related parties, not less than 66% in value of the financial debt, for the filing of an application for initiating PPIRP in such form as may be specified. So here again, this provision is kind of a replication of the previous one which you have seen. Now the previous clause E pertains to the approval of the unrelated financial creditors for appointment of an IRP, of an RP. Here subsection 3 is for the approval of 66% or greater of the financial creditors, unrelated financial creditors, for initiating the PPIRP itself. Therefore, as you can see, there are two approvals which need to be taken, one prior and one after obtaining the internal approval through special resolution or 3/4 resolution. Now subsection 4 says, prior to seeking approval from FCs under subsection 3, the corporate debtor shall provide such FCs with the declaration under 2F, the special resolution under 2G, base resolution plan under 54K, and such other information and documents as will be specified. So here this is the part where we were referring to, where before the unrelated financial creditors will have a say on whether or not the application is to be allowed, since they will also have to make an informed choice or an informed decision. It is the onus is upon the corporate debtor to provide the financial creditors with all the documents that are necessary for them to take that decision. Now these documents include, firstly, that an approval has been obtained, and that we are declaring that this PPIRP is not to defraud anyone, and immediately after approval we shall be filing an application within 90 days. Secondly, what is the special resolution that has been passed? That the company itself is in line with the idea of filing an application for initiating PPIRP. Thirdly, a base resolution plan as envisaged under 54K, so that the unrelated financial creditors have an idea as to what exactly they can expect out of the PPIRP and any other documents which may be required. Now coming to section 54B. What are the duties of the insolvency professional before initiation of PPIRP? So here again you can see, although the code does not explicitly deal with the 3 stages, the wording of the provisions and the structure in which the provisions have been arrayed clearly show that PPIRP is a stage-wise process as compared to the CIRP, which is more linear in nature. Now coming to 54B, what are the duties? The IP proposed to be appointed as the RP shall have the following duties commencing from date of approval under clause E of subsection 2 of 54A, namely 1. Prepare a report in such form as specified, confirming whether the CD meets requirements of 54A, and if the base resolution plan confirms the requirements under 54A4C. B. File such other reports and documents with the board as may be specified, and perform other duties as may be specified. So here, as you can see, the initial role of the insolvency professional, he is not yet the resolution professional, is to ensure that whatever compliances are required under 54A, which are the initial compliances, are in place so that the PPIRP can be subsequently initiated without there being much hassle. Now subsection 2 is crucial here. It says duties of the IP under subsection 1 shall cease if A. CD fails to file an application for initiating PPIRP within time period under clause F, or the application for initiating PPIRP is admitted or rejected by the adjudicating authority. So here we see there are 2 contingencies based on which the insolvency professional will cease performing the duties that are put under him under section 54B. keep again in mind that this does not mean that he will not be the RP. This only means whatever duties are there prior to PPIRP, those will come to an end, right? Now, that is true in the second case. However, in the first case, if the corporate debtor has not even filed an application for initiating PPIRP, this insolvency professional will not be the RP. Therefore, he will become functus officio. In the second case, also, if the application is rejected, there is no need for him to continue. If the application is admitted, however, he will be the RP, for which subsequent provisions are there. Subsection 3 deals with the fees payable to the insolvency professional, which basically says it will form part of the PPIRP costs, which is a standard provision we've seen across CIRP for the RP and for the liquidator in the liquidation process. Now coming to section 54C, which deals with the application, the requisites of the application for initiating PPIRP. Subsection 1 says, whereas CD meets the requirements of 54A, a corporate applicant thereof may file an application with the adjudicating authority for initiating PPIRP. So as discussed, here it will be the corporate applicant, which is the MSME itself and not any of its creditors. And the first requisite here is that the informal stage is met, which is section 54A is met. 54C therefore is the second stage, which is the application stage. Now subsection 2 says it shall be filed in such manner and form as specified. For this, the relevant regulations are the PPIRP regulations of 2021, which again are quite similar as to CIRP regulations, just that they cater more to the PPIRP. So because they are not very different as such, we do not have to go through them in detail. Now this is also similar to the application filed by a financial creditor under section 7 or under section 9 or 10, which is what are the accompanying documents to the application. Corporate applicant along with the application shall furnish a declaration, special resolution and approval of FCs for initiating PPIRP under section 54A. These are the documents which are pre-initiation stage or the informal stage that we have seen. B, name and written consent of the professional to be appointed as the RP as approved under 54A2E and his report which is referred to under 54B1A. Therefore here not only are you going to furnish details and written consent of the RP, you will also be giving the adjudicating authority the report which the RP has prepared showing that the CD is eligible for undergoing PPIRP and showing that the base resolution plan is in consonance with the provisions of 54A and 54K. C says a declaration regarding existence of any transactions that may fall within the scope of chapter 3 or fraudulent or wrongful trading under chapter 6 in such manner specified, which again is a requirement we have seen previously. D, information relating to books of accounts of CD and such other documents relating to such period as may be specified. So these are under the rules which you will find all of these. Subsection 4 says adjudicating authorities shall within a period of 14 days of receipt either admit the application if it is complete or reject it if it is incomplete. However, the proviso clarifies if it is incomplete, 7 days time shall be given for rectification of all the errors. Right. This also we have seen in the other provisions dealing with application. Now subsection 5 says PPIRP shall commence from the date of admission of the application under clause A of subsection 4. So this also is quite similar to what we have seen previously under CIRP, which is the date of commencement is the date of admission. Now coming to 54D, which is a very crucial provision as it outlines the time limit within which PPIRP has to be completed. Now keep in mind that here we are dealing with resolution for MSMEs. MSMEs by themselves are very smaller companies, right? Therefore, it does not make any sense to have the same time limit as is provided for all other corporate debtors, right? Therefore, and in case of MSMEs, given the entrepreneurial aspect and other related aspects, there is a need of expeditious resolution, right? So this aspect has very well been considered by the legislature in prescribing the time period, which as you can see under subsection 1 is 120 days from the commencement of the PPIRP. Right, therefore within 120 days the entire from the date of its commencement, the entire PPIRP has to be completed. Now subsection 2 says without prejudice to subsection 1, the RP shall submit the resolution plan as approved by the COC to the adjudicating authority within 90 days from the PPIRP commencement date. Therefore, here you can see the first checkpoint that needs to be crossed is within 90 days you need to submit an approved resolution plan before the adjudicating authority. Subsection 3 outlines the consequence, that is when no such resolution plan has been filed, then the RP will file an application to the adjudicating authority for termination of the PPIRP in such form and manner as may be specified. So here there are no provisions for extension, right? You can see that the legislature is focusing more on expeditious resolution, due to which the timelines are quite strict here as compared to what we have seen previously for CIRP. Now under section 54E deals with moratorium and public announcement, something we have seen previously. However, there are certain differences which we shall be going through. Now subsection 1 says adjudicating authority shall on the PPIRP commencement date along with order of admission A. declare moratorium for the purposes of 14(3)(1) which shall mutatis mutandis apply to PPIRP, and B. appoint an RP as named in the application if there is no disciplinary proceedings, or if the IBBI makes any recommendation, if any disciplinary proceedings, if there are any disciplinary proceedings before the IBBI, then based on the recommendation made by the board, that recommendation will be taken into consideration. And C. cause a public announcement of the initiation of PPIRP to in such form and manner as may be specified immediately after his appointment. Therefore, this public announcement, the duty is on the RP. However, the duty of imposition of moratorium, as has also been the case with CIRP, will still lie with the adjudicating authority. Subsection 2 clarifies, order of moratorium shall have effect from the date of such order till the date on which the PPIRP comes to an end. Therefore, that is quite logical. That is the reason behind why a moratorium is imposed under the IBC, which we have seen when dealing with section 14 of the code. Now coming to section 54F, what are the duties and powers of the resolution professional during the PPIRP transaction, during the PPIRP process, right? So here this is stage 3, right? What we have seen previously under 54B relates to duties of the insolvency professional prior to commencement of PPIRP. Here it is duties and professional of the RP during the PPIRP process, right? So 54F is in the subsequent order of things. Now subsection 1 says the RP shall conduct PPIRP during the PPIRP resolution process. Now the following duties shall be performed which are under subsection 2. A. Confirm the list of claims submitted by the CD under 54G, which we shall see subsequently. Inform creditors regarding the claims as confirmed under clause A. Maintain an updated list of claims. Monitor management of the CD's affairs. Inform the COC in the event of breach of any obligations of the board of directors or partners under this provision and the rules and regulations made thereunder. Constitute the COC, convene and attend all of its meetings. Prepare the information memorandum based on the preliminary IM submitted under 54G. File application for avoidance of transactions and other duties. So these are something. Apart from a few of these, we can see that the duties of the RP which are there under CIRP are what are being prescribed here also, stipulated here also under PPIRP. Now the powers of the RP under subsection 3 are A. to access all books of accounts and records of information available with the corporate debtor, access electronic records of the CD from an information utility, access books of accounts, records and other relevant documents available with government authorities, attend meetings of the members, BODs and committee of directors, partners, etc., appoint accountants, legal or other professionals, collect all information relating to assets, finances, operations, etc., including information pertaining to business operations, financial payments, list of assets and liabilities and other matters as may be specified, and take such other actions as may be specified. Now subsection 4 clarifies, from the date of appointment of the RP, the financial institutions maintaining accounts of CD shall furnish all information relating to the CD available with them to the RP as and when the RP requires that. So here again this is quite similar to what we have seen before in the CIRP proceedings, where the RP has the power to collate and collect all relevant information of the corporate debtor for the benefit of the creditors and for the purposes of the resolution process as a whole. Here subsection 5 lays a duty on the personnel of the CD to cooperate with the RP. This is also what we have seen previously. Fees of the RP shall and any expenses incurred by him shall be determined in specified manner, and COC can limit conditions and limits on such fees and expenses, and whatever fees that have been incurred by the RP prior to constitution of the COC, that shall be subject to ratification by the COC. Now 54G is another crucial provision which deals with the list of claims and preliminary information memorandum. Now the corporate debtor shall within 2 days of PPIRP submit to the resolution professional following information updated as on that date in such form and manner, which is of course 2 days. These information will be relevant or up to date in respect of 2 days from the commencement of the PPIRP. What are these? List of claims along with details of respective creditors, if there is any security interest involved, if there are any guarantors to those transactions, etc. And a preliminary information memorandum containing information relevant for formulating a resolution plan. Now subsection 2 and 3 and 4 deal with a peculiar situation, right? This situation is where the preliminary information contains any information basis which a person has incurred losses, right? Then the liability for those losses is fastened upon the promoters and directors of the corporate debtor or any person who has authorized the submission of list of claims in the preliminary information memorandum by the corporate debtor. Basically, these provisions exist for one simple reason, that as opposed to what we have seen under CIRP, the information memorandum, at least the preliminary information memorandum in a PPIRP, is prepared by the corporate debtor itself, right? Because this is one document which will have to be furnished to the creditors. Therefore, here the liability and onus will naturally fall upon the directors and promoters and members of the corporate debtor. Now, subsection 3 is our clause that we've seen generally, which says if you do not have any knowledge or consent over whatever mistakes are there in the or misleading information is there in the PPIRP, then you will not be held liable. Now subsection 4 provides a right to any person who has suffered losses due to any wrong information in the PPIRP to move any court having jurisdiction for seeking compensation for any losses or damages that they have suffered. Now coming to section 54H, which deals with management of affairs of corporate debtor. This is also a very crucial provision which marks a key difference between CIRP and PPIRP. 54H says, during the PPIRP period, A, management of affairs of CD shall continue to vest in the board of directors or the partners of the corporate debtor subject to conditions as may be specified. So here, as opposed to it going to the RP as under CIRP, here it will be continue with the board of directors. The reason behind this we have already seen, which is basically to ensure that the MSME has a say in its own resolution and its interests are not curtailed by financial creditors and unrelated financial creditors and other creditors. B says, clause B says, the board of directors or partners, as the case may be, of the CD shall make every endeavor to protect and preserve the value of the property of the CD and manage its operations as a going concern. So a duty is laid upon the BOD. This is just to say, just because you have a say over how the resolution process will take place does not mean the process will be subjected to your whims and your fancies. There has to be checks and balances, which is why clause B has been incorporated. Clause C says, promoters, members, personnel and partners of the CD shall exercise and discharge their contractual or statutory rights and obligations in relation to the CD, subject to the provisions of this chapter and such other conditions and restrictions as may be prescribed. So here there is a semblance of normalcy in the operations of the MSME which is sought to be ushered in to ensure that the process of the PPIRP does not by itself hamper the functioning of the MSME and lead it to suffer more losses, right? So this is the main reason why behind why 54H has been incorporated into the PPIRP provisions. Now coming to 54I, which deals with the committee of creditors. Now here 54I subsection 1 says, the RP shall within 7 days of PPIRP constitute a committee of creditors based on the list of claims confirmed number under 54F2A. It says that the composition of committee of creditors shall be altered on the basis of updated list of claims in such manner as may be specified, and any such alteration shall not affect the validity of any past decisions of the COC. So here we have seen this also occur and recur throughout the PPIRP provisions, which is an updated list of claims will have to be maintained, and this list is subject to revisions. Proviso clarifies that just because there are revisions made, whatever decisions have been taken previously by the COC will not be affected in any way, right? Now, subsection 2 clarifies the first meeting of COC shall be held within 7 days of its constitution. And subsection 3 says, whatever is there under section 21 except for subsection 1, which deals with the time period and first meeting, etc., these provisions under 21 will mutatis mutandis apply to in relation to the COC under this chapter. And the proviso merely clarifies that any references to resolution professional under subsection 9 and 10 of section 21 will be constituted as references to corporate debtor or the resolution professional, because here under PPIRP the corporate debtor will play a role which is similar to what the RP does. Therefore, references under section 21 will also have to include, especially under subsection 9 and 10, will also have to include references to the corporate debtor. This is what the proviso clarifies. Now coming to 54J, which deals with vesting of the management of CD with the RP. Therefore, we have previously seen that in PPIRP, the management will vest with the CD. 54J is brought in to ensure that in some cases where the management, if it vests with the CD, will cause detriment to all the stakeholders involved and will impact the overall PPIRP process as a whole, it is then essential to vest the management with the RP and ensure that the CD does not have control over it. What are these scenarios? We can see under the provision. Now here subsection 1 says to make this move, right, to ensure that the management is vested with the RP, this has to be done through an approval of more than 66% of the COC. Right, now it says on an application under subsection 1, if the adjudicating authorities of the opinion that during the PPIRP either the corporate debtor's affairs have been conducted in a fraudulent manner or there has been a gross mismanagement of its affairs, right. In these two cases, an order shall be passed vesting the management of the corporate debtor with the resolution professional. Therefore, here we can infer that the committee of creditors will firstly have to ascertain that either there has been fraud in conducting of the management of the CD or there has been gross mismanagement of the affairs of the CD, due to which with a 66% majority the COC says applies to the adjudicating authority requesting that the management be vested with the RP and that it does not continue with the board of the CD. Now here subsection 3 just enlists certain provisions in relation to the the CIRP, especially under 14, 17, 18, etc., which shall mutandis apply to proceedings of this chapter from the date from which an order is passed vesting the management of the corporate debtor with the resolution professional. Therefore, this is a very clarificatory provision and it just extends the scope of the CIRP, or rather it makes the scope of the CIRP applicable to the PPIRP now that the management is being vested with the RP, and therefore the RP will have certain additional duties which are envisaged under previous provision of the CIRP chapter. Now coming to another crucial provision, which is 54K, consideration and approval of the resolution plan. Now subsection 1 says the CD shall submit the base resolution plan under 54A4C to the resolution professional within 2 days of the PPIRP commencement date, and the resolution professional shall present it to the committee of creditors. Now keep in mind that there is already a base resolution plan which will be submitted to the unrelated financial creditors that we have seen previously, right. This resolution plan which is being submitted here is more statutory and formal in nature, because now we are in the third stage, which is the formal stage of the PPIRP proceedings. Therefore, here the CD will again have to submit the base resolution plan, this time to the RP. Now because there is an updated list of claims, there are more creditors who might have come in, there might be more classes of creditors who have come in. So for all of them to be covered, it is essential that the base resolution plan is now within the custody of the RP, right. And then the RP will subsequently submit it and present it to the COC, as is the process which we have also seen under CIRP. Subsection 2 says the COC may provide the CD an opportunity to revise the BRP prior to its approval under subsection 4 or prior to its invitation of PRAs under subsection 5. This again is to ensure that the MSMEs plan to revive itself is not thrown off right away. Rather, the MSMEs board is given an opportunity to look into the provisions of the plan, take insights from the COC and then amend it prior to any other action being taken by the COC. Subsection 3 says the resolution plan and the BRP submitted in this section shall conform to whatever is provided for under section 30 subsections 1 and 2. And it also says subsections 1, 2 and 5 of section 30 will mutant is applied to the proceedings under this chapter. This is basically to say, however the nature of a resolution plan should be for a CIRP, the same essentials and the same requirements will also have to be fulfilled in case of a resolution plan or a BRP which is being submitted for a PPIRP, right? That is the only purport behind subsection 3. Now subsection 4 is of high significance because it says when can a COC approve a BRP for submission to the adjudicating authority. There is one crucial condition, which is if it does not impair any claims owed by the corporate debtor to the operational creditors. So here again we have seen in the CIRP, and there is a lot of jurisprudence to this question, where the position of operational creditors under CIRP is always been such that there have been cases where they have received a haircut so much so that what they receive is nil or zero, right? The logic behind this is under section 53 they would be receiving zero, right? However, under PPIRP you will have to necessarily prove, the COC will have to necessarily look into the aspect of the resolution plan not impairing any claims that are owed to the operational creditors of the corporate debtor. So this again is crucial because in MSME, when it comes to MSMEs at least, operational creditors will have a more crucial role to play, right? So that is the genesis behind this provision, which is specifically putting an onus on the COC to look into this aspect as discussed. Now subsection 5 deals with what will happen if the plan does not conform to whatever has been provided for under the previous subsections. It says where the COC does not approve the BRP, or if the BRP impairs any claims owed by the CD to the operational creditors, then the RP will invite prospective resolution applicants to submit a resolution plan or plans to compete with the BRP in such manner. Now these are the BAPs, right? So they will call for other resolution plans, of which one plan will be chosen, which is the BAP, that we shall be looking into subsequently. Subsection 6 says the RA submitting the plan pursuant to invitation under subsection 5 shall fulfill such criteria as may be laid down by the RP with the approval of the COC, having regard to the complexity and scale of operations of the business of the CD and such other conditions as may be specified. So again here this provision has been put into to ensure that at least in case of MSMEs, any person who is willing to act as a resolution applicant has a complete understanding and a bird's eye view of the operations of the corporate debtor, and the plan itself will be able to sustain the operations in a manner that is fruitful to the corporate debtor as well as the resolution applicant. Now subsection 7 says the resolution professional shall provide to the resolution applicants the following information. 1. Basis for evaluation of the resolution plans which is approved by the COC, and B. The relevant information which is under section 29. Whatever is there under section 29 will mutant apply here. So all that information which we have seen under 29 will also have to be furnished to the resolution applicants by the resolution professional. Subsection 8 says the RP shall present to the COC for its evaluation plans which conform to the requirements referred to under section 30 subsection 2. So this again we have seen the jurisprudence of the role of the RP in ensuring that the requirements under 32 are met. Now subsection 9 says the COC shall evaluate the resolution plans presented by the RP and select a resolution plan from amongst them. This is the BAP, which is the best alternative plan. Now coming to subsection 10, which also deals with this, which is where on the basis of such criteria as may be laid down by it, which is the COC decides that the RP, the plan selected under section 9 is significantly better than the BRP, such resolution plan, this becomes the BAP, right? Such resolution plan may be selected for approval under subsection 12, provided that criteria laid down by the COC shall be subject to conditions as may be specified. So that again is subject to the rules thereunder and the other conditions that the RP will provide. Now coming to subsection 11, it says where the plan selected under 9 is not considered for approval or does not fulfill the requirements under subsection 10, it shall compete with the BRP in such manner subject to conditions as specified, and one of them shall be selected for approval under subsection 12. Therefore, it basically says when the COC has considered the plans, when it has evaluated it, and then it does not see that it is automatically better than the BRP, in that case it will have to necessarily compete with the BRP, and then basis on such competition, if the COC comes to a view that okay, either the BRP is better or the BAP is better, then one of them will be approved under section 12. Section 12 says the plan selected for approval under 10 or 11 as the case may be approved by the COC for submission to the adjudicating authority, provided if it is under section subsection 11, which is after competition and comparison, if it is not approved by the COC, the RP shall file an application for termination of the PPIRP in such form and manner as to be specified. So here, even when you compared these two plans and you find that neither the BRP nor the BAP is suitable, then the RP will have no other option but to file an application seeking the termination of the PPIRP. Now subsection 13 says the approval of the plan under 4 or subsection 4 or subsection 12 as the case may be by the COC shall be by a vote of not less than 66% of the voting shares. So this is something that we have seen previously. So that is basically to say, either when you are approving the BRP at the first instance itself, or if you have compared the BRP with other plans and are then approving a BAP, in both these cases the requisite majority is 66%. Secondly, the COC will also have to look into the following: the feasibility and viability of the plan, manner of the distribution which is proposed, which is basically a waterfall mechanism, and the priority under section 53, which is a waterfall mechanism, and the priority and value of security interest of a secured creditor, and any other requirements as may be specified. So this again is quite similar to what we have seen in CIRP, and all those judgments and all those aspects and the jurisprudence which we have seen there will naturally apply here, because at this stage we can see that the PPIRP has merged into an ordinary CIRP proceedings. It is the same PPIRP, just that the nature has now converted from an informal stage to a much more formal stage, which is regulated in a manner similar to the CIRP. Subsection 14 says, while considering feasibility and viability of a plan, where the plan submitted by the CD provides for impairment of any claim owed by the corporate debtor, the COC may require promoters of the CD to dilute their shareholding or voting or controlling rights in the CD. Now this is somewhat a shift with respect to the interests of the board and promoters of the MSME. This is basically to say, if the plan provides for any haircut of any creditors and the COC feels that this can be avoided by diluting the shareholding of a promoter in the MSME, then the COC can require such dilution to be done. This again is keeping in view the uniqueness of MSMEs as compared to regular and other corporate debtors. Now it says that provided where the plan does not provide for such dilution, COC shall, prior to approval of such plan, as the case may be, record reasons for its approval, right? So where there is a case that there is an impairment or a haircut being provided, but still the COC is approving under subsection 4 or subsection 12, then it has to record reasons as to what are the reasons that enabled it or that assured it to overcome this dilution aspect, despite it having the right to request the promoters to dilute their share. So that we can understand is logical, because it is more to do with what is the logical step here, right? When the law itself provides you with an option of ensuring that the creditors do not suffer and the dilution of shareholding can be done, why have you not gone through it is a reason that needs to be separately provided. Now the explanation 1 basically says the corporate debtor, being a resolution applicant under clause 5 of section 5, may submit the BRP either individually or jointly with another person. This also we have seen previously. And for the purposes of subsections 4 and 14 of this section, claims shall be considered to be impaired where the resolution plan does not provide for the full payment of the confirmed claims as per the updated list of the claims maintained by the RP. Therefore, wherever there is, let's say, a claim of 100 rupees but the plan provides for 80, that will be considered as an impairment, right? Now, basis that impairment, a call will be taken by the COC. That is secondary. Wherever there is an impairment but that 80 rupees does not translate to dilution of shareholding in the MSMEs promoters, then reasons have to be provided by the COC. That is the entire conspectus of this provision. Now coming to the approval of the resolution plan. So till this stage, procedurally, what all have we seen? Firstly, we have seen an informal stage where the PPIRP's initiation itself is looked into firstly by the company itself, the MSME itself, who will then have to pass a special board resolution, make certain declarations with respect to the fact that this PPIRP is not to defraud any creditors, and within 90 days from the date of approval by its unrelated financial creditors, an application will be filed and a base resolution plan will be provided, will be created, and a preliminary information memorandum will be created, all of which will be provided to the unrelated financial creditors, who will then appoint an insolvency professional to with a 66% approval, and all of this will happen prior to the application being filed. Subsequently, the application will be filed by the IP for PPIRP, and he has his own set of duties which he will have to perform, and then the onus is then on the adjudicating authority to admit or reject the application within 14 days with the caveats mentioned thereunder. This is the second stage, right, the application stage. After the application stage, the PPIRP becomes more similar to the CIRP, where a moratorium is imposed, a limited moratorium is imposed, the IRP will be appointed, and his first duty is to make a public announcement. And from there on, we have seen how the proceedings will go in the same manner as the CIRP, with few exceptions. What are these? Mainly that the management of the corporate debtor will vest not with the RP but with the corporate debtor itself, which is subject to change, and the fact that the entire PPIRP proceedings will have to be completed within 120 days and not 180 days or the outer 330 days as we can see in a general CIRP. So till here it's quite similar, and then comes the resolution plan. The committee of creditors will then again be provided with the base resolution plan by the IRP, by the RP, right? The RP will, after providing the base resolution plan, the COC will give the CD a chance to revise it. Now, if this post all of that, if the COC feels that the BRP is good as it is, then it will approve the same, right? Or then PRAs will be, that is prospective resolution applicants, will be invited by the resolution professional, who will submit their plans. The COC will compare the BRP and the other plans and select one plan, or if this is not done, then the PPIRP will be terminated. So till this stage we have seen the PPIRP proceedings. Now comes the duty of the adjudicating authority. Therefore, here you can see in the PPIRP stage, the interference on the duty of the adjudicating authority is quite limited, right? 54L. If the adjudicating authority is satisfied that the plan is approved by the COC under subsections 12 or 4 of section 54K and subject to the conditions thereunder, meets the requirements referred to under section 30 subsection 2. So here also it will be 30 subsection 2 which is being looked into and not any other provision, because like we have seen, the resolution plan there and the resolution plan here are the same thing. So whatever requirements are there will have to be looked into here. And this is also a very crucial clause which we have seen in CIRP, which is prior to passing any approval, it has to satisfy that the plan also has provisions for effective implementation. And here we can see the binding effect, which is envisaged under section 31, 1, 3 and 4 subsections, will also muted and mutant is applied to the proceedings under this section. Yeah. Now coming to what happens if the plan does not conform to whatever requirements are there under the previous subsection. Then within 30 days of receipt of such resolution plan, the adjudicating authority will reject it and pass an order under section 54N, which we shall see subsequently. Now here is another very crucial aspect. One of the other aspects which now the adjudicating authority will have to look into is whether the resolution plan is approved will have the effect of changing the management of the corporate debtor, right? Only if the corporate debtor's management is changed can the plan be approved by the adjudicating authority. What is the reason behind this? It's quite simple. Now the entire process in general, keeping the exceptions aside, PPIRP in its entirety, the management of the CD will vest with the CD itself, right? So if any base resolution plan is being admitted or if any other plans are being admitted, this CD will be having a say in it, right? Now it gives the CD the leeway to continue being it gives the management of the CD the leeway to continue being the management, right, of the corporate debtor even in its revived form, which will defeat the entire purpose of the PPIRP. The reason why the PPIRP has been brought in most cases, is due to the faulty management, right? Now you cannot again give the entire management back to the PPIRP and call it revival. That will defeat the entire purpose. Therefore, here it is essential that the management of the corporate debtor will have to change. If it does not, then the adjudicating authority will do three things. One, reject the resolution plan. Two, terminate the PPIRP. And three, declare that any PPIRP costs that have been incurred will be included as part of the liquidation costs. Therefore, PPIRP will go and liquidations will commence. Now 54M specifically provides for appeal against an order passed under this section where a resolution plan has been rejected by the adjudicating authority. The grounds for this are same under section 61 subsection 3, which is also a routine provision that we have seen for appeals from an order passed by the adjudicating authority in CIRP. Now coming to the termination of PPIRP. Now here again we have seen previously two cases where the resolution professional will file an application before the adjudicating authority seeking termination of the PPIRP. This is under 54K12, which is when no plan has been approved despite comparison being done between the BRP and the BAPs, or under subsection 3 of section 54D, which is basically when the plan is not approved within the application is not made within the 90 days that has been promised by the corporate applicant. In these two cases, the RP will apply for termination before the adjudicating authority. When such application is made, the adjudicating authority shall, within 30 days from date of such application, by an order, 1. Terminate PPIRP, and 2. Provide for manner of continuation of proceedings initiated for avoidance of transactions. So again, just because the PPIRP is terminated does not mean that the corporate debtor can walk away scot-free of whatever fraudulent transactions that it has been done, of which cognizance has been taken by the RP. So that is the logic behind these the clause 2 under this subsection. Now subsection 2 provides for another ground, which is where the RP at any time after PPIRP commencement date but before approval of the plan intimates the adjudicating authority of the decision of the COC, which is again approved by 66% majority, to terminate the PPIRP, then an order under subsection 1 will be passed by the adjudicating authority. This is basically giving the leeway to the committee of creditors to terminate the PPIRP when it feels that its continuance will not be of any use to any of the stakeholders involved. Subsection 3 basically says when termination is done, the corporate debtor will bear all the PPIRP costs. Again, this is because PPIRP is initiated at the instance of the corporate debtor. Therefore, costs, it makes no sense to impose the costs on any other entities as opposed to the corporate debtor. Subsection 4 says, notwithstanding anything to contrary contained in this section, where the adjudicating authority has passed an order under subsection 2 or section 54J, and the PPIRP is required to be terminated under subsection 1, then an order shall be passed by the adjudicating authority for liquidation under section relevant provisions of section 33, and the PPIRP costs shall be included as part of the liquidation costs, which we have also seen previously. Now here is a very interesting and crucial provision, right? This says initiation of corporate insolvency resolution process. Now here we have seen certain differences between PPIRP and CIRP, right? But why has the provision specifically been incorporated for initiation of corporate insolvency resolution process when there are other provisions through which the management will vest in the RP? This is what is clarified under 54O. Just the reading of 54O will give us that necessary clarity. Subsection 1 says the COC at any time after the PPIRP commencement date but before approval of resolution plan under 54K, again 66% majority, may resolve to initiate a CIRP in respect of the corporate debtor if such corporate debtor is eligible for the CIRP under chapter 2. And again the similar provisions is the RP will have to make the application before the adjudicating authority seeking that it be done as a CIRP and not a PPIRP. For this again the adjudicating authority will pass an order with three things. PPIRP will be terminated, the RP will be appointed now as an interim resolution professional. So here in PPIRP there is no IRP, which is the interim resolution professional. There is firstly an insolvency professional at the informal stage who then becomes a resolution professional at the formal stage. However, if it is becoming a CIRP, then it is mandatory that he becomes an interim resolution professional. And lastly, that the PPIRP costs will now be included in the CIRP costs as opposed to the liquidation costs. Subsection 3 basically says if the written consent is not provided by the interim resolution professional, then the IRP will be appointed by making a reference to the IBBI for recommendation and that manner. Now subsection 4 says when such an order is passed not converting necessarily, terminating PPIRP and initiating CIRP, then there will be 5 things which will happen. Firstly, that order will be similar to an order of admission of a section 7 application. Therefore, here it will be the commencement of the CIRP date. Second, CIRP shall commence from the date of order naturally, which A and B are to be read in consonants. Clause C says proceedings under chapter 3 shall continue. This again we have seen in previous positions, it's just in provisions, it's just a logical corollary. Clause D says for the purposes of 43, 46 and 50, references to insolvency commencement date shall mean PPIRP date. And E, in computing relevant time period for avoidable transactions, time period during PPIRP shall also be included. This is just to clarify that merely because CIRP is now being commenced, whatever provisions have been initiated under 43, 46 and 50 for avoidance will not start afresh. So the commencement date there will still be referred to as the PPIRP commencement date. However, everything else is the same. The corporate letter is the same, the process is the same, everything, the creditors will mostly be the same. It's just that avoidance and all these transactions will be, the proceedings thereunder will be still deemed to have been commenced from the date of commencement of the PPIRP. That is the only difference. 54P here clarifies the applicable provision under 2, 3, 6 and 7 to this chapter and what are the other definitions which will remain unchanged. Now these are just, you can give a cursory look to all these provisions, but basically if you have understood the entire schematic of the PPIRP and how it relates to the CIRP, then these provisions, whatever is there under 54P is merely of a clarificatory in nature. Now before we proceed with fast track insolvency, the reason behind 54O of the IBC. Now as we have seen, one of the major differences between PPIRP and CIRP is that the resolution plan, the base resolution plan that is, will be prepared by the corporate debtor itself. Therefore, here it's not an external resolution applicant who will be preparing it, right? Therefore, the risks and the associated adverse implications for the creditors are a little higher. In this aspect, CIRP is a much more foolproof and much more safer option. So, to ensure that this option is not cut off from the creditors, 54O allows the COC to convert PPIRP into a CIRP and ensure that the base resolution plan is not the sole document basis which this entire process is being handled. Therefore, the CIRP, which is more comprehensive, that aspect can be taken into consideration. That is the only reason behind section 54O. Now coming to FTIRP, before which we shall see one small judgment of the NCLT in Krish Realtech Private Limited, and there is no respondents here. The reason for this being the factual scenario. Now in this case, what has happened is PPIRP proceedings were initiated, right? The proceedings were pending. Now certain third parties sought to raise some objections and intervene in the proceedings. They filed applications etc. before the NCLT. And the NCLT said, yes, you can intervene, right, and allowed their application. The corporate debtor subsequently filed an appeal before the NCLT saying that the objective of the IBC, which is also laid down by the Honorable Supreme Court in EBIC's judgment, is to ensure that it is time bound and completed in a time bound manner. The revival of the corporate debtor should be done in a time bound manner. If you allow objections and interventions by all XYZ parties, it will only derail the process. This was the ground on which the appeal has been filed. Now here the NCLT has done something which is to look into the reason behind constitution of the NCLT itself under the Companies Act, which is the NCLT as well as the NCLT. It says the NCLT or NCLT shall not be bound by procedure under CPC but shall be guided by principles of natural justice and shall have power to regulate their own procedure. This is one aspect. Secondly, the statutory scheme under 3A does not indicate any prohibition on the adjudicating authority to hear any objector or intervener before admitting an application of PPIRP process, right? So here the process has been initiated but the application is not made. The second stage is not yet reached, but the objections are being raised and interveners are trying to come before the adjudicating authority, which the corporate data says cannot be done. However, as rightly pointed out by the NCLT, one, there is no prohibition on this under 3A, part 3A. Second, the NCLT and NCLT itself is constituted and bound by the principles of natural justice. Therefore, it can listen to any objections which are being raised. Despite this being so, a caveat is being issued by the NCLT, which is, we are cautious that proceedings under IBC are time bound, where unnecessary delay has to be avoided by the adjudicating authority, and given time to objections which are meritless and giving time to objectors and interveners has to be exercised on sound discretion and valid grounds. Therefore, here it has to be a very, very well reasoned order as to why these objections are being considered. In this case, this specific case, there are serious allegations which were raised, and therefore the NCLT upheld the NCLT's decision to listen to the objections of the objections which have been raised against PPIRP proceedings. So yeah, one such ground is if an application filed under 54C does not meet the statutory requirements, it is always open for a person who has a claim in the PPIRP to point out that the application does not follow the statutory provisions. So this exactly is the reason behind why objections and interventions can be allowed before the second stage is formally initiated. So that is a very crucial judgment, is what the NCLT has passed in this judgment. I'm just leaving the screen here so that we can take a screenshot of this. Right. Now coming to the next chapter, which is chapter 4. This you can see has not been initiated or included through an amendment, but it was there in the original code itself. Now, fast track corporate insolvency resolution process, right? Before we go into the provisions, again, why is this being brought into the IBC, right? For the main reason being, the IBC follows a creditor in control model, right? As opposed to other legislations which have a previous insolvency and bankruptcy legislation which had a debtor in control model. Therefore, the scheme under the IBC envisages a win-win situation where if you put the revival of a corporate debtor within the control of its creditors, the outcome which will happen is not only is the corporate debtor getting revived, but such revival is not happening at the detriment of the creditors. Understandably, there are some haircuts, but this again is within the approval and necessary oversight of the creditors itself, right? So this win-win process, perhaps the legislature felt cannot be extended only to some cases. It will be unfair to leave it out to other companies as well, right? So there are certain class of companies to which this CIRP will be extended to. However, because of the nature of these companies and their size, a comprehensive process might not be beneficial, due to which it is necessary to incorporate a smaller process, which is why fast track CIRP has been brought into the IBC. Now here there is a notification by the IBBI bringing certain amendment to the FTIRP. These amendments are now what is reflected in the present IBC as it currently stands. Now as you can see here, these provisions, which is the provisions for FTIRP, came into force with effect from 14 June 2017. IBC came into effect in 2016. These were brought into effect in June 2017. So let's see these provisions and simultaneously read the notification so as to understand the present status of fast track CIRP. Section 55 says, a CIRP carried out in accordance with this chapter shall be called a fast track CIRP. Subsection 2, an application for fast track CIRP may be made in respect of following CDs. 1. CDs with assets and income below a level notified by the CG, the central government, or CD with such class of creditors or such amount of debt as may be notified, or C such other category as may be notified by the central government. Now here, under para 2 of this notification, you can see that the central government has notified the following corporate debtors in respect of fast track CIRP, which is basically 1, a small company as defined under Companies Act 2013, a startup defined under the relevant notification of the Ministry of Commerce and Industry, and 3, an unlisted company with total assets as per financial statement of immediately preceding financial year not exceeding 1 crore. So these are the 3 companies in respect of which a fast track CIRP can be instituted. Now section 56 says what is the time period. Now keep in mind that for PPIRP it is 120, for CIRP it is 180 plus 150, 330. However, for fast track it is within a period of 90 days from the insolvency commencement date, right? And subsection 2 says what is the extension. Extension can be granted by an application by the RP beyond the 90% date if the committee of creditors approves it by a vote of 75% of the voting share as opposed to the usual 66%. Now what is the period by which such an extension can be done? Such extension can be granted by the adjudicating authority but not exceeding 45 days, right? So here it is 135, which is 90 plus 45, 135 days. For PPIRP it is strictly 120 days. For CIRP it is 180 plus 150, which is 330 days. Now section 57 says manner of initiating fast track CIRP. Application for fast track CIRP will be filed along with 1, proof of existence of default as evidenced by records with information utility or such manner that the IBBI may specify, and 2, such other information as may be specified by the board to establish that the corporate debtor is eligible for fast track CIRP, which is basically any documents evidencing that the company is either a small company, a startup or an unlisted company whose financial statements show that of the last year show that its total assets does not exceed 1 crore rupees. 58 basically says whatever provisions for conducting a CIRP and the provisions pertaining to penalties under chapter 7 will apply to this chapter as the context may require. So this again is a very clarificatory provision. Now coming to the notification, it deals with each of these provisions, which basically says that to implement the provisions of the code, the board has enacted the 2017 regulations, which is the IBBI fast track regulations. However, it is observed that these regulations are not being much used by the stakeholders for initiating. So based on all of these aspects, and given the fact that not much changes happened in the fast track regulations, which was last amended on 7 February 2018, and despite multiple amendments to the CIRP but no corresponding amendment to the fast track CIRP, there is a probable case for reviewing the process under the fast track resolution process. So this is basically envisaging some amendments to the fast track CIRP to make it more in line with the CIRP procedure. So these are just clarificatory in nature, but the notification in itself gives us an idea as to how the fast track CIRP stands as on today, right? So that's it about the fast track CIRP. It is not much in practice, as can also be seen by the notification that we have just read. Therefore, there is a dearth of jurisprudence when it comes to the provisions on these. However, as the years go on, it is hoped that the IBC is now seeing a good success, and this success will extend to the companies undergoing fast track CIRP. So that brings us to the end of this session, and hope you all now have a basic idea of both PPIRP as well as fast track CIRP and how they relate to the CIRP and how they adhere and how they fall within the whole ambit and objectives of the IBC Code of 2016. Thank you very much.